Sergeant at Arms, can you please, just looking at the hall, can you please call our colleagues, our Republican colleagues, to the session hall? It's 9:25. So I see Speaker Pangilinan, Senator Munya Barnes, Senator Rodriguez, Senator Mike Nicholas, Senator Frank Uggan, Vice Speaker, Senator Tom Ada. Okay, we have 8, enough really to start, but so the clerk.
Senator Tom Ada. Present. Senator Tony Ada.
No, move on.
Senator Uggan. Vice Speaker Cruz. Senator Duenas. Senator Limtiaco. Senator McCready. Senator Morrison. Senator Munya Barnes. Senator Pangilinan. Senator Respicio. Senator Rodriguez. Senator Nicholas. Speaker Wampat.
Geiger.
Senator Yamashita. Madam Speaker, there is a quorum.
Thank you very much. Thank you, colleagues, for being here this morning. I know we've never really started exactly on the hour we would like to, but we do have 8, and we will proceed. So we left off yesterday with now Bill 108-32 by the primary sponsor, Senator Tina Rose Munya Barnes. You are recognized.
Masi, Madam Speaker. Madam Speaker, I'd like to ask if I can move to accept Bill 108-32 as substituted by the Committee on Rules, Federal, Foreign, and Micronesian Affairs, Human and Natural Resources, and Election Reform, and as further substituted on the floor.
On that motion, without
And
any objections?
hopefully everybody has the
So
updated
ordered.
copy.
Everyone, yes, has a copy. I do have a copy as well.
Okay. Madam Speaker,
Motion to...
motion to move then to, thank you, Madam Speaker, motion to move to third reading, and if I can discuss briefly on it.
You may
And
proceed,
Manana
Senator.
Sidus, thank you for letting me do this. Madam Speaker, this Bill 108-32 COR is an act to amend sections 44103, 44105, 44108, and 44114, and 44115 of Chapter 44, Title 10, Guam Code Annotated, and to repeal sections 44106, 44109 of Chapter 44, Title 10, Guam Code Annotated, and to amend sections 4505 of Chapter 45, Title 10, Guam Code Annotated, and to amend section 51504 of Chapter 51, Title 10, Guam Code Annotated, and this is relative to the Guam Beverage Container Recycling Act of 2010, and the power of the Guam Environmental Protection Agency to implement the same. Madam Speaker, Bill 108 seeks to do four main things, and I'm going to say the first one is it changes definitions in the provision to bring the law more in line with both the mainland states of Hawaii and California, whose similar legislations have had to be changed because of implementation problems. These changes will head off further implementation problems if we don't do this. A next provision that we'd like to take care of is that it eliminates the artificial distinction between on and off premises consumption. This change makes it clear that deposit fees apply to all containers, whether for on or off premises consumptions. The next clarification is that it clarifies that the Guam Environmental Protection Agency has the power and the authority to implement the bottle law. And this also allows for the use of the Recycling Revolving Fund to be used to fund the implementation of the law. This, Madam Speaker, I will tell you, has been a major setback in the past because the lack of resources to move forward with the full implementation. I want to say, Madam Speaker, for the record, that this Bill 108 is the result of many months of collaboration between our offices, the Guam EPA representation with their division, but also more importantly, their legal counsel who was assigned from the Attorney General's office. We've worked closely with Region 9 and also with US EPA. And in our efforts to continue to work and protect the environment, Madam Speaker, this is just one of the many steps that, that we should be taking to work in that direction. And Madam Speaker, I also want to say that for the record to my colleagues in the hall, that legal counsel is here, my legal counsel, legal counsel is here, and also a representative from the Environmental Protection Agency who's been really taking the leadership to make sure that we bring all these concerns to this body and make sure that we make the changes. And they're here if there's any questions this body might have to move this bill forward. Madam Speaker, I want to thank my colleagues, and as you know, Madam Speaker, when the Beverage Container Act of 2010 was implemented, it took a very long time. And as we look at protecting our island, making it a greener, healthier, cleaner Guam, and making sure that we look at also opportunities to turn trash into a commodity, we said that this, doing the what everyone would know as the bottle bill, was looking at legislation to that effect. And when it was implemented over 3 years ago, and like I said, for those who know that it took us a very long time to try and get the Beverage Container Act of 2010 to be implemented back then. 3 years later, we're still having some obstacles, and I'm saying that with the collaboration with all the government entities and us working closely with a couple of the states that have similar legislation to ours, but also working with Region 9 and US EPA, I'm hoping that the concerns that are addressed in this bill and that we're fixing, that we will be able to finally look into having our Guam EPA do a good implementation so that our people who continue to collect beverage containers and plastics and all that they would be given that opportunity to be involved in making Guam a cleaner, greener, and healthier Guam. So thank you for giving me the opportunity to speak. I know I didn't take up my time, so I hope my colleagues will look at this measure and help me support as we want to have a greener, cleaner, healthier Guam. Sana Masi.
Welcome, Senator. On the motion, Senator St. Nicholas, you're recognized.
Thank you, Madam Speaker. I do have a quick question as I'm navigating through the bill, if the author will so yield.
Senator, there's a question. So can you go ahead and ask the question?
On page 5, line 3, it references subsection 44119. Yeah, I'm not I don't see that section here in this bill, and so I pulled up the section on the existing GCA, and it does not appear to be consistent with what the intent of that entire paragraph is trying to accomplish. Is there a new subsection 44119 language in the bill, or am I looking at the wrong section here on the existing GCA?
Madam Speaker, can I just take a moment recess just so I can confer with him?
Okay, we'll
Thank you.
brief recess. Senator Nicholas, you still have the floor.
Thank you, Madam Speaker. In conference with the author, I have been, it has been clarified as to how that section is relative to the entire act. So I'm satisfied on that. I did have a question on page 4, on lines 6 through 14 as well for the author. In the first sentence there, lines 6 through 8, beginning 1 year from the date this act takes effect and every 2 years thereafter, the department shall notify deposit beverage distributors in writing of the amount of the deposit beverage container fee. The effective date of changes to said fee amount shall be 1 month after said notice. And the way I'm reading that language, Madam Speaker, is that if the fee were to change, the department must notify, and then only after notification 1 month thereafter will that fee change take effect. I'm just curious how that applies to new businesses that were to open up as deposit beverage distributors, because the way I'm assuming the bill would operate is if I opened up as a new business and there was a new fee, I would probably immediately have to pay that new fee. And then, but I'd be paying a new fee while the existing distributors don't have to pay that new fee until they're notified and 1 month thereafter. That's kind of how I'm interpreting it, and if my interpretation is incorrect, if I could get clarification on that, because there may be a problem if a new distributor were to come in and pay a higher fee than what everybody else is paying. How would a new distributor be affected by any fee changes?
Senator, do you yield to the question?
I'm going to attempt this, Madam Speaker. The change in fee will occur, when the notification's out, the change in fee will affect everyone, those in and those out. And even if a new business were to come in, the fee that's set then will apply, and if the notification's out and the changes are made, then everybody will be affected at one time.
Senator?
I understand the intent, but that's not quite how I'm reading the interpretation, because it says here that the department shall notify every 2 years thereafter. So if you're an existing deposit beverage container business and there was a fee change, you won't be notified until maybe 2 years later. And then after that 2-year period, then there's another 1 month window before the fee takes effect. But if I came in and I opened up a new deposit beverage container business and there was a new fee already in place, I would immediately be paying that new fee while the existing deposit beverage container businesses will probably be waiting 2 years until they get notified that the fee is actually changed. So a new business might be paying a higher fee, while the existing businesses are still paying the lower fee because the 2-year notice hasn't gone out and the 1-month clock hasn't started.
Senators, if you, Speaker Pangilinan, I'm sorry, I can't have, we're going to recess
No,
until you
Madam
guys.
Speaker, I'll answer.
Okay, wait, then because there were other conversations, and the only thing that's going to be in the journal, of course, is whoever I recognize, and right now then, the senator has a question, but he's now in another conversation, so, sorry, recess. back in session. Senator Munya Barnes, you're recognized.
Sizus Masi, Madam Speaker. Madam Speaker, if I may, I'd like to ask my colleagues if I could just do a motion to set this aside so that we can work out all the legal technicalities and make the necessary amendments so that it becomes a cleaner bill, and then if we can come back as soon as we're ready. I thank you for the opportunity to work with me on that.
Thank you, Senator. Then, is that on the motion that the senator is asking for? To set
Yes,
aside?
Madam Speaker, and I think maybe while the staff is working on coming up with another substitute bill that incorporates these numerous amendments, I think it's important that we put on the record, and I really would like to get the answer put on the record as to why here we are 3 years later after the bill has been after the law has been enacted, that it hasn't been implemented. And it's very clear in the law that it says that nothing gets implemented until everybody's on board. Guam, the civilian sector and the military sector. And so as I understand it, we still do not have that memorandum of agreement effected with the military to be able to participate also and put a deposit fee. So I would like to ask the sponsor of this law to for the record clarify why aren't we there yet?
Thank
Okay.
you, Madam
No,
Speaker.
we're not going to do it now, though. We'll do that when we come back. You mean you want her to say now where we
Well,
are, like a status?
Because the staff
An
working
update?
on putting together the substitute bill, I think that kind of will be a good way of, I believe that at least the explanation that was given to me, I think is a good way to leave this and return to it later so that we all understand why do we keep tweaking and tweaking and tweaking and still the program is not yet implemented.
I understand. So, Senator, would you then be willing to go ahead and give like an update in terms of, where?
Now or later?
I think now maybe to
Okay.
kind of explain it. So,
I could share with you as it relates to the military. Madam Speaker, the military has been very much engaged in working closely with our government on trying to move this bill forward to implement it. They have committed to work an MOU with the understanding that the rules and regulations would be in place. And once the rules and regulations get finalized, that they will then take the rules and regs and work with the MOU and do the official signing. They have given that commitment. It is a part of the statute, but they want the rules and regulations are in front of them as that commitment from the government. That is why Bill 108 is there, and Bill 108's amendments in it share a lot of the issues that needed to be tweaked out before the bill could be implemented. We are going to make several more amendments so that the bill becomes cleaner, and then we'll come back when it's ready to be able to share it with my colleagues, if that's okay.
Thank you, Madam Speaker. So based on that explanation, then, is it accurate to say then that the amendments that are being made to the existing law are the concerns that will address the concerns that the military might have, before they will agree to signing an MOU to also put a deposit fee on the beverages that they bring in? Is that what I'm hearing?
It's a
Senator?
compilation. It's a complying of all the concerns, Madam Speaker, that Region 9, the states of Hawaii and California, working closely with Guam, have come together working with U.S. EPA and Guam's EPA to make sure that we don't have the same mistakes that are happening in the other states. And until these provisions are addressed and taken care of and submitted into the statute, then we can finalize with Guam EPA the final rules and regs, and then come to us, but also then work with the military, because they see the final rules and regs, that they will be able to sign an MOU with the government of Guam. But they have shared that commitment. Even as we speak, after the implementation of the bottle bill in 2010, it wasn't even a month later on a new term that there was a roundtable discussion, and that commitment from the military was still there. But incumbent upon that, we work with the rules and regs and Guam EPA in their efforts to trying to implement that with the advisory, with the council members. There are things that need to be tweaked and amended. So this is where we're at right now, Madam Speaker. And again, I will continue to make the necessary legal technical changes to better strengthen this bill moving forward.
Senator
So
Ada?
if I can just have a little of,
Okay.
of your time.
But So Senator Ada, then was she able to
So
answer
Madam
your
Speaker,
question?
then, in so many words, what I understand then is that we are making amendments to the law, but it does not necessarily address whatever concerns the military may have. It addresses concerns that EPA may have, trying to get away from the Hawaii model. But my question was, are these amendments addressing the concerns that may be keeping the military from entering into an MOU to implement this program?
Madam Speaker,
Senator?
thank you. I thank the good senator for that question. The military wants to see the rules and regulations.
First.
First, EPA, Guam EPA, have been collaborating with the different stakeholders necessary to implement this Beverage Container Act. And until the amendments are made and a final draft is given by Guam EPA, that we can be able to move forward with the military's cooperation as committed by them. So the holdup is not the military right now, Madam Speaker. In simply put, it's being able to make sure that when we complete and correct the obstacles with the concerns of Guam EPA and the collaboration of all the stakeholders, that it's necessary that we make these changes.
Okay, so then the motion, there's no objection on the motion then to have legal counsels then work on and to answer any concerns on a new substituted bill. And then it will be set aside until such time that, Senator, you're ready. Please let the chair know, and we will proceed with your bill. So,
Sana
order.
Masi.
Okay, so this takes us now to Bill 133. Speaker Pangilinan?
Thank you, and Census Masi, Madam Speaker. Madam Speaker, I'd like to move that Bill 133-32 COR be placed in the third reading file, and I'd like to discuss the bill.
Okay, Senator, you may proceed.
Thank you very much, Madam Speaker. Madam Speaker, Bill 133-32 would continue the efforts of this legislative body, both past and present, to ensure that the public is informed of decisions made by its government and the way that those decisions are handled with regards to access of those decisions and the information related to those decisions to the general public and to the taxpayers. What the bill does, Madam Speaker, is it provides very simple amendments to the current process that occurs with regards to the settlement of claims against the government. The bill does not change the manner, the fashion, or the ways or the authorities vested in current public officials in the handling of claims against the government of Guam, with the exception of one single area, and that is that the claim shall become final when the Attorney General or whoever is negotiating that settlement concludes his negotiations and then seeks appropriation to fund the payment of that settlement. So that would be the only change with regards to the current authorities. But it doesn't change the processes that somebody settles a claim with the government of Guam. And so what this does is it makes sure that the settlement claims that are decided on and approved by the government of Guam shall become open and public and shall be available for public inspection, so that any settlement of any claims concerning the government shall not be sealed and shall be open to public inspection, and that the Attorney General or the attorney for the agency shall send a copy of each settlement to the Speaker within 5 days of the approval of Imagalaginguahan. So we don't inject ourselves into the settlement claim process. We don't remove any authority of the governor to settle these claims, but we do require that the legislature be notified when those claims are final. And then the settlements of the lawsuits also, Madam Speaker. Again, it is very important. It is very important that when we enter into settlements, that we don't keep the people involved in those settlements waiting forever to be paid. That's what happens sometimes, Madam Speaker. And I remember a really unfortunate case where the government actually settled a claim for some JFK students that were involved in an auto accident in a sanctioned event by the Department of Education. And as a result of that auto accident, fortunately, no individuals were killed, but we had people injured that, and one young lady was injured so severely that she had to receive care off island. She's had ongoing medical problems that she had to deal with, and she wasn't able to get any kind of compensation at all. But they settled the claim, and for years and years, she had to struggle, her family had to struggle to provide her with the resources necessary to take care of that injury that resulted from a government-sanctioned event. And so what actually occurred in that situation, Madam Speaker, was when it came to my attention in my office, we actually restructured the tort claim process and the prioritization of payments of tort by the government of Guam. And as a result of that change in the law, we not only fixed her specific problem, we were also able to fix future claim problems on tort issues with regards to those individuals that are awaiting settled claims by the government. So we kind of fixed that over the years. It's the other claims that may result from business transactions, contract disputes, and things like that. Now that sometimes, look at what happened with Maeda. Again, you know, the settlement occurred, actually that was a court case, but the settlement that occurred after the court case was adjudicated, you know, they still ended up having to wait so long, and in the end what we did was we gave away the government asset of land to a private company in order to settle that because we didn't have the money to pay for it. So what this does is when they settle, it comes to the legislature, and then we need to ensure that we do our part in looking at the settlement agreement and then appropriating the necessary resources to at least ensure that the appropriation and the authority to pay that claim exists. And so then it becomes the prerogative of the administration, as always, even without, for example, an appropriation, to try and prioritize in the budget of payment of those claims. But at least we and every single branch of the government agrees that this is something we want to do, and we provide the necessary authorities in law to do so. So that's why we require that those settlements come to the legislature and we appropriate the money and act on it. And so the settlement of any claims concerning the government of Guam, again, must not be sealed and must be open for inspection. And so, Madam Speaker, those really are the major changes with regards to the settlement and the handling of settlement claims against this government. We don't interfere with the judicial process in allowing the judicial process to enter into those disputes, adjudicate those disputes, and issue their orders. We're just saying that once that's done, once again, they can't seal that should be open to public inspection, Madam Speaker. And so, Madam Speaker, once again, like I said, this legislative body, this legislative branch, has continually sought to ensure that where opportunities exist for us to keep our public informed, and where the doors are closed and the sun doesn't shine, that we will open those doors so that the sun can come in, and every public citizen will have a right to know what is being obligated on their behalf by this government, from the executive and the legislative branch, Madam Speaker. And that is what the type of government that I feel our public deserves, that I want to give them, that this legislative body has a history of doing so, ensuring openness and transparency in all of the government processes. And so I thank my co-sponsor on this bill. I was really pleased when I presented this to him, and the concept, given his background, of course, and where he comes from and where he practices. And I also want to thank each and every member of this body that will give due consideration for this. And I ask that your due consideration will hopefully result in a positive vote on this bill. Thank you, and Census Masi, Madam Speaker.
You're welcome, Speaker Pangilinan. On the motion, I have Vice Speaker Cruz.
Thank you very much, Madam Speaker. Madam Speaker, I rise in full support of this piece of legislation. I always want transparency. And I was wondering if either you or the main sponsor could assist or would yield to an inquiry that I have. The question that I have, Madam Speaker, is that I monitor the correspondence that comes into your office, and I have seen on occasion letters from the Attorney General's office stating that there is a settlement that has been reached and that they may need something. So I'm wondering, when your office gets the letter that says a settlement has been reached, who is responsible for introducing the legislation to appropriate that money, or who is responsible for implementing whatever law is necessary to effectuate that settlement? The letter was addressed to the Speaker, and I have enough legislation. I don't need to be pulling those and saying that I want to introduce legislation to do that. But I'm just wondering, when those letters come to the legislature and they're posted, is there a protocol that I should be advised of, or the other members ought to be advised of, that when they see those letters, that who's responsible for introducing the legislation to effectuate the settlement?
Speaker Pangilinan, did you hear the question? Either you or I, but I'm up here, so.
I think when these settlements are agreed upon, of course, all settlements have to be approved by the governor. So in my opinion, it is when that settlement is agreed to, signed by the governor, to approve it and to provide the resources to make it effective, then I think that the governor should be sending down legislation saying, I've approved this settlement, I need an appropriation of such and such in order to pay it, and should submit a bill to the legislature. That's the way I perceive that situation should be handled.
Well, that's my problem right now. I'm just trying to figure out, there's this whole big fight as to, with this elected Attorney General, it's completely separate. When they sign a settlement, does that still have to go to the governor for approval, or is that the settlement of the government of Guam?
Can I ask if Senator Respicio, as COR, when these documents or letters come in, I know that normally the process would be is that it would be, yes, addressed to the Speaker's office. It comes in, it gets stamped, we prepare a document to the legislative secretary as well, and then it gets referred, of course, to the individual respective jurisdictions, right? And that's what COR would do. So from there, then, Senator Respicio, maybe you might want to respond to that, please.
Yeah, you're correct, Madam Speaker. Whatever correspondence comes to this legislature and it's addressed to you, and the legislative secretary makes all these messages and communications known to the other senators, what the Committee on Rules does is we go through all those messages and communications, and we try as much as possible to refer those matters that would require the attention of that committee of jurisdiction specifically rules and regulations and proposed settlements, and also the legal counsel has called to our attention from time to time those legal matters facing the legislature. Thank you.
Mr. Vice Speaker, I mean, between the three of us, that maybe there might be another way to make sure that this is captured somehow, if it should be through the governor's office.
What I can do, Madam Speaker, is I can, because the Attorney General is over my oversight jurisdiction, I can maybe put together even a roundtable discussion on just that specific, because I think it's very important. So I agree with the Vice Speaker in terms of trying to clarify that portion of how it should be handled.
Okay, thank you very much, Mr. Speaker. Mr. Vice Speaker, you still have the floor if you have any other comments or questions. I guess not. Is there anybody else who would like to speak on the motion? There being none, then, Mr. Speaker, would you like to close, or you want to just send it down?
Thank you very much, Madam Speaker. Madam Speaker, once again, I thank the body on this, and I hope that this legislature, or the legislative branch, in its efforts to ensure continued openness and transparency, will see that policy carried forward during this legislative term. And I think that Bill 133 is a positive step in that direction. And I thank everyone for their consideration.
Very welcome. And on the motion then to send Bill 133 to the third reading file without any objections, so ordered. Offer. Is it something very substantial? Okay, maybe later on you can speak to the majority leader about a motion. Speaker Penglin would discuss that with you. I'd like to recognize Senator Uggan on Bill 134.
Buenos dias, Madam Speaker. Good morning to our fellow colleagues. Madam Speaker, there was first of all, I'd like to move for acceptance of a particular amended version, and I apologize, the number of the bill was not inserted into the version that was being circulated. And just so that there's an understanding of what changes were incorporated, it was simplified a bit more in terms of just designating the Office of Veterans Affairs.
Senator, can you make a motion to accept this
Yes,
version first?
Okay. Madam Speaker, if I can move for the acceptance of Bill number 134 COR, the version that reads as amended on the floor.
Okay, on that motion without any objections, so ordered. Now for placement to...
Thank you, Madam Speaker. I'd like to move for the placement of Bill number 134 COR in third reading with minor discussion, please.
Yes, you may proceed, Senator.
Thank you, Madam Speaker. I just didn't, I apologize for not following the protocol, but I just did not want the body to accept that for discussion, not knowing exactly what the differences were. But it was simplified to a great extent. It's just more or less now, rather than requiring the establishment and the maintenance of a Guam Veterans Registry, it's designating the Office of Veterans Affairs as the official government entity for maintaining such a registry. And this was an issue that was brought up a while back, Madam Speaker, during the course of one of our roundtable discussions, because statements were circulating as the chair of Veterans Affairs, were circulating that in fact we have about 13 to 16,000 veterans on island. And acknowledging that those numbers may be directly reflective of what the real numbers are out there, unfortunately, our 2010 census identified 8,041 veterans. So if you look at the disparity, that brought into question a lot of issues in regards to how do we bring this to a more realistic figure that would reflect not only the retirees, but also all of the Guard members, all of the reserve members who are veterans in their own right. So this, Madam Speaker, hopefully would move in the right direction in terms of ensuring that the Office of Veterans Affairs now would be not only officially designated for maintaining a Guam Veterans Registry, but moving in the direction of ensuring that we can solidify that number. And I'll give you some excellent example. Madam Speaker, when I looked at some of the information that is being gleaned. I just shared with you the information with regards to the 2010 census, which is obviously the number that most of the federal entities, whenever federal grants are being applied for, they would rely on that because that is an official number out of the census itself. Well, in this case, there's additional information that the committee was able to glean in terms of looking at the overall numbers. Right now, we have 1,586 members in the Guam National Guard, both the Air and the Army component. We also have more than 500 reserve members, whether it be in the Air Force Reserve, in the Army Reserve, in the Navy Reserve, in the Coast Guard Reserve, and then eventually, I believe there's one other component. I apologize if I did not highlight them. But looking at all these numbers, it tells me, Madam Speaker, that the numbers that we have based on the 2010 census is not truly reflective of the veteran population on island. And let me just provide one additional information. And this is with the Department of Veterans Affairs, which provides benefits to our retirees, not our active duty, not our reserve component members, but our retirees and those who are utilizing some of the benefits in addition to their retirement annuity. Just the U.S. Department of Veterans Affairs, in calendar year 2012, there were 8,913 beneficiaries or identified veterans who were utilizing the system and receiving benefits, whether it be their retirement stipend or annuity or educational benefits or some of these other benefits that are administered directly out of the U.S. Department of Veterans Affairs. So I apologize for confusing you with all these numbers, but census 2010, 8,041. Guam National Guard, 1586. You look at the reserve component of about 500. Then you look at the U.S. Department of Veterans Affairs that does not include active duty personnel, does not include reserve component of 8,931. It tells you that we really need to figure out a way to get to the threshold of making sure that we can solidify the veteran population on island. So, Madam Speaker, it is very self-explanatory, and I simplified it a bit more so that, in fact, there will be that official designation out of the Office of Veterans Affairs. I want to thank those who provided testimony and recognized the need to be able to reconfirm or reaffirm the number of veterans in the community. I also know that there's a good number of veterans who have repeatedly brought this as an issue that we as a community need to figure out how many veterans are retired, how many veterans, and keep in mind the definition, Madam Speaker, of a veteran is someone who has served and who has left the U.S. Armed Forces either in a retiree status, who are still in the reserve component, or who have served in the U.S. Armed Forces for a duration of at least 120 plus days and have been discharged honorably. So, Madam Speaker, those are our components that we certainly need to get down to the bottom of this in terms of making sure that we can identify exactly what our veteran population is. And I believe Bill number 134 would assist in moving in that particular direction. Thank you very much, Madam Speaker.
You're welcome, Senator. On the motions, Senator Yamashita.
Thank you, Madam Speaker, for giving me the opportunity to speak in full support of Bill number 134-32. Madam Speaker, it was yesterday on another measure, one of our colleagues talked about how sometimes a measure is so common sense, but yet sometimes we need to introduce legislation that is common sense. And for me, it would seem that the Office of Veteran Affairs would already be driving towards this and knowing that this is a part of their mission and would have already been succeeding in this. And as I've been to I've been to many of the Veteran Commission meetings, and I sit and I listen to that community. I am very concerned that we don't have an updated database. I am concerned that we don't have our veterans identified, and I am concerned that the supports and services that they should be getting as a veteran, to include their families, are not being received. And so hopefully the Veterans Affairs Office will pay attention to this, which I'm pretty sure will be turned into law, and become very serious about going out there. And I know they tell me the vets don't want to be registered. I mean, that's what some folks will tell me. But Madam Speaker, when you talk to them, they don't have a problem being registered. If you know how to talk to somebody, if you help them if you help them understand why this will help them and us, it's not an issue. I also know Sarah Thomas Netadog, and she's associated with very many nonprofits and social work groups, but there's a particular organization that she's working with who I know is really trying to get our veterans registered. And so with her work, with this kind of mandate, I've always suggested working through the mayors, because honestly our mayors know where our vets are and where and how to find them. We can figure out the protocol to make the vets understand why this would be really helpful to them, especially in the line of health services. Vets over and over again will say that they need better access to health service, and they appreciate a clinic, but what they really need is a hospital, and they need counseling services, and the list is there. So I appreciate the author of this measure. I'm very glad that this is being discussed, and I hope that it passes. Thank you, Madam Speaker.
You're very welcome. Senator Tomata, you're recognized on the motion.
Thank you, Madam Speaker. I rise in support of Bill 134-32. I think it's certainly important to designate by law the official office that will be collecting this information, from which then many other will be the basis for many benefits that we will be pursuing for our veterans. However, I'm concerned that as written, one might interpret that only the data that's collected by the office will be the official data. So if only 100 veterans go down to the Veterans Affairs Office in Asan, then that's the entire database. So I would like to proffer an amendment to broaden then how that information is collected. And the amendment would be on line 12, page 1, I would add the following sentence. The office may use data collected at other government agencies which may be collecting the required data in whole or in part. So with that amendment, for example, then the Department of Revenue and Taxation, vehicle licensing, and the vehicle registration. We do have the laws which basically grants the benefit to veterans that if they just bring up and show their military ID, they can get their new driver's license or renewal for no fee. So that's the incentive for them then to to get their driver's license and register as a veteran, and then from that, Rev and Tax can compile the information and provide that to the office. So certainly that would be another point of collection, but we're only, I guess the law only will recognize that only data that comes from the Office of Veterans Affairs will really be the official count. So this amendment would basically then imply that the Veterans Affairs Office is going to have to reach out to these other government agencies that may be collecting the same data that we are needing. The University of Guam, I'm sure the students, when they register, I don't know, maybe they do collect data that says that he's had military service or whatever, but I mean, so maybe in part that registration information may at least provide a lead for the office to say that, okay, here's some new veterans, especially the ones just coming back from the Middle East who are signing up now, and then try and come up with a program to get them in. I'm not sure what other, I imagine Department of Administration may also have a database that of employees, applicants that basically have invoked their military preferential points, and there's another point there. So it's going to be incumbent on the Veterans Affairs Office to really kind of go outside of their realm there, their office, and go to these other points of collection and gather that information so that they can come up with as complete a database as possible. So that, Madam Speaker, is my amendment to Bill 134, and I'll get together with
And can I ask, Senator, can you please read it one more time?
the end. A sentence at the end of line 12 would read, "The office may use data collected at other government agencies which may be collecting the required data in whole or in part."
Okay, thank you very much. And you do have a copy to give to the
Yes.
clerks. And on Senator Tom Ada's amendment, I recognize Senator Uggan.
Thank you very much, Madam Speaker. Madam Speaker, I certainly stand in support of the proposed amendment. Anytime that you involve other government of Guam entities that could provide some additional statistics with regards to solidifying the number of veterans on island is only going to be beneficial. Just to share with members of the body, that's one of the reasons why you have the secondary paragraph within that section, which reads, "All government of Guam entities, whenever applicable, shall render assistance to the Office of Veterans Affairs in carrying out the provisions contained therein." The proposed amendment is much more specific to that effect. So I certainly appreciate that, and I support it. And obviously, I acknowledge that it's the sponsor of the amendment who had legislated that, in fact, some of the benefits be administered out of revenue tax in terms of the driver's license, because part of that law authorizes or requires that revenue tax disseminate and provide and share information with the Office of Veterans Affairs. I understand that that process has yet to be set up in terms of that direct communication and link, but it's certainly very helpful, especially when we have 3,973 veterans right now who are taking advantage of the driver's license benefit that the sponsor of the amendment has administered. Thank you very much, Madam.
You're welcome, Senator. Is there anybody else who'd like to speak on the amendment? There being none, Senator Ada, do you want to close on that amendment, or, okay, so, any objections to the amendment? There being none, so ordered. On the main motions, are there anybody else who would like to speak? There being none, Senator Uggan, do you want to close or send it down?
I will make this very quick, Madam Speaker, and just putting some rough numbers together, and I need to clarify, I did mention a little earlier during my presentation that there were more than 500 reserved. Actually, I received the most recent number, and it's 1,040, which is all inclusive of all of these reserve components. And obviously, when you have a reserve component on island, they're composed of residents of Guam. So just looking at very rough estimates, looking at the U.S. Department of Veterans Affairs number, only because, like I shared a little earlier, their benefits are rendered to retirees and other veterans who have been identified as qualifying for some of those programs, such as disabilities and whatnot, and then the National Guard. Just with those three components, those numbers, we're up to 11,557. So it really tells the story in terms of the 8,041 is quite off base in terms of truly reflecting the veterans community in our island, and I encourage our colleagues to support this measure, and I thank you for the discussion. Thank you, Madam Speaker.
You're welcome, Senators. On the motion to send 134 to the third reading file. Oh. Yes, I just saw two other hands, even though I had closed, had Senator Uggan close. Senator, does it have to do with your amendment, Senator Tamada?
Madam Speaker, yes. It just brought to my attention that maybe we really need to put a phrase in there that says that, by virtue of setting up designating the Office of Veterans Affairs as the official GovGuam agency for maintaining the Guam Veterans registry, that if anybody by law was tasked to maintain that data already, that this law does not relieve them of that responsibility. How do you language that more concisely?
Legal counsel, I'm looking to our legal counsels right now to find out whether should we take a recess to prepare the language to that effect. I have Senator, I'm going to go ahead and have you work with legal counsel right now, and Speaker Pangilinan has his hand up as to speak, so I'll come back to you.
All right, thank you.
So Speaker Pangilinan, on the motion.
Thank you very much, Madam Speaker. Madam Speaker, I think this bill assists the policy of this government in trying to maximize the resources that we devote to assist our veterans get what is due to them, not only from what we provide locally in terms of relief, but also what is due to them from the federal government that is dependent on information and data and statistics. So while we've gone back and forth, you know, we kind of always debate what's the real number, what's the real need, and then we kind of say, yeah, but whose number is correct and who are we going to rely upon? You know, we had, I still don't have the final results, but my understanding was the delegate from the U.S. Congress to Guam, Madeline Bordalio, had supposedly was going to go door to door and do a veteran survey to once and for all positively identify all the veterans on Guam who have provided service in defense of our nation and our country, and use that data in order to ensure that all of the legislation that is passed by the federal government providing services and resources and assistance to our veterans, that Guam will get what is due to it. And I've never seen the final results of that, you know, in terms of what was the end of that door-to-door, or was that, you know, actually carried out, or was it just you know, something that they said they were going to do and at a town hall meeting, and then it wasn't followed up on. So I think that this goes a ways towards then compiling the data from the different resources and then trying to sort it out, issue it as the official data regarding veterans, those who served the country and our island, and then use that information and turn that over to the appropriate federal departments and agencies that administer veterans benefits in terms of either for veterans services itself, as well as healthcare services that are available through other programs of the federal government, mortgage programs, etc., and then get our veterans what is duly deserving for the sacrifices that they have given on behalf of our nation, and certainly on our island, that has given this community an opportunity to stand up and be proud for the services that they have provided, and most especially for what we always hear from every single military official that comes through Guam, that when the Guam soldier is serving his country and our island, whether it's in Africa, the Horn of Africa in that, or whether it's in Camp Lejeune, North Carolina, that he is an excellent soldier, great attitude, dedicated to the work that he performs, and always makes ground proud. And I think that we have to then do what we can for that type of service and that type of representation that they give the people of Guam, that we do our share to make sure then that once they conclude that service to our nation and our country in the proud manner that they always do, giving rise for our pride here on Guam, that we do our share and make them proud of the work that we do and the support that we give them by doing our job right and doing it well, just as they have. Thank you, and Sidus Masi, Madam Speaker.
You're welcome, Speaker Pangilinan. So, is there anybody else who'd like to speak on the motion? Senator Ada, are you ready with your amendment? You're ready with your amendment? Okay.
Thank you, Madam Speaker. The additional amendment that I have to be added at the end of the first amendment that I made shall read as follows. Nothing herein shall relieve the duty of any other entity to collect veterans' data for the benefit of veterans on Guam.
Thank you, Senator. Does everybody understand the amendment? Anyone needs a copy? Okay, so no objections? So ordered. Thank you. Senator, please make sure that the clerks get a copy. So On the motion then to send 134 to the third reading file without any objections, so ordered. Okay, she's not here. Senator Tommy Morrison on Bill 140. There you are. 140, that's 32. Senator Morrison, you're recognized. 140.
Thank you, Madam Speaker. I move to place 140 into the third reading file. I'd like to speak on it.
And it's not amended, okay, as introduced.
As
Yes,
introduced.
So to, okay, as introduced. Okay, Senator, you want to speak on it then. So it's a motion then to place it?
Yes, into the third reading file.
All right.
Thank you,
You may
Madam Speaker.
continue.
Bill 140 will amend Section 2 of Public Law 25-55 relative to 911 charges. Public Law 2555 granted an exemption to subscribers who had more than 25 lines from paying a 911 surcharge on those additional lines. This provision was enacted despite the fact that every one of those additional lines had access to 911 charges or services. Every state, Madam Speaker, since 1999 required all wireline and wireless phones to be assessed a 911 surcharge. There's no exemptions for those who subscribe to more than 25 lines. Bill 140 essentially eliminates the cap of $1 for up to 25 lines and charges a standard $1 per line fee, thereby charging a fixed fee per line. Madam Speaker, this bill was a result of public safety agencies coming together and expressing concern about the need to upgrade and modernize the technology of the E911 system. I do share the disappointment of my colleagues, Madam Speaker, of many previous legislatures have worked very hard to address this critical system and trying to modernize the system. I'm also extremely shocked from learning from the public hearing that our E91 system does not have a permanent home, and for the past 5 years, the E91 system has moved 5 times. God forbid anyone's had to use our E91 system during that period. According to a report from the Office of Public Accountability, Guam's emergency response system is antiquated and incompatible with the modern technology that we have today for E911 systems. GFD continues to operate an E911 system, emergency management services, with the same E911 system purchased in the late 1990s. Madam Speaker, we're looking at a system that is about 25 to 30 years old. According to the audit report, the E911 system is capable of identifying a caller location for landlines, but is unable to determine locations for callers using wireless cell phones, a function now readily available with technology today. Madam Speaker, Bill 140 provides equity and fairness to all telephone subscribers. Mostly provides support for one of Guam's most critical services. My intent here is to ensure that our Guam emergency 911 system is up to date and keeps pace with technology and has the proper resources to support the ever changes of technology for this system. Madam Speaker, we don't address this proactively, this could literally mean the difference between life and death. With cell phone lines that are more prominent today than landlines. If I may, Madam Speaker, to address some of those concerns from my colleagues and some of the concerns that were also addressed in or at the public hearing, I would like to move to proffer 2 amendments, if I may, Madam Speaker.
Yes, and I was actually wondering who these amendments are from, so please, if you can, all those of you who are going to be submitting amendments, that you indicate your name so that I know who to call. So thank you. So you do have 2 amendments.
Yes, Madam Speaker.
Thank you. So you may proceed.
The first amendment, Madam Speaker, is to add a new section 2 as follows, and renumber the existing section 2 and section 4.
Okay.
It's the Enhanced 911 Emergency Reporting System Fund Restrictions. Madam Speaker, a concern raised at the public hearing was the use of the fund for operational use, and clearly the fire chief or the acting fire chief at the time was stating clearly that they basically have no control of this fund, basically. So what this amendment does, Madam Speaker, is it protects the fund, and it prevents it from any transfer authority as well, and from any other uses, except primarily for the purposes of the purchase and modernization of the E911 system. So, Madam Speaker, this will clearly protect the use of that fund specific to the E911 emergency reporting system.
Okay, so everyone has a copy then of Senator Morrison's amendment, which is to create a new section 3, and it's an amendment to Public Law 25-55. No, which one? Oh, I'm so sorry, I was looking at, all right. Add a new section 2 as follows, and renumber the existing 2 as section 4. Okay, see then.
That's correct, Madam Speaker.
All right, so would anyone like to speak on the amendment? Speaker Pangilinan, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, I certainly support the amendment. I do want to say that really this is the case today. But the problem that occurs, of course, is when the governor submits his budget, he will have the budget for E911 as a revenue source. And then he would appropriate the money or allocate in his budget a portion of the E911 collections for E911, and then he takes the balance and he puts it over to fire department. So even if we pass this law, it doesn't prevent the governor from submitting a budget that takes money out of E911 and uses it for other purposes. And as long as the legislature passes that budget with that provision in there, it gets used for that purpose. So I understand the intent, and we do that with just about every single special fund. We say no other purpose of that, but once the governor submits it and we don't change it in this body, then it's allowed to be used. So I agree with the intention of E911. I agree with dedicating it to that purpose. But again, it's just that, does it really get implemented? It's the same with the Territorial Educational Facilities Fund. The original enabling legislation is for the improvement of the capital facilities of our public education system. But the governor sent a budget down that used it for power instead of capital projects to improve our educational facilities instead. And because of the challenges that we have and what we juggle in here when we pass the budget, it allowed it to be used for power. So I certainly agree, but I just want to point out the realities of what we've had to deal with over the years as we set up these special funds. And if we just say, notwithstanding that section, E911 revenue gets to be allocated to fire, and we say, yes, it will be allocated to fire. But I agree with putting it in here, stating the intention, and maybe every time we look at that budget, we have to say, all right, are we going to let him do this, or we're not going to let him do this? And then say no, remove the appropriation for fire, and then find the other resources that he puts in for fire. It's very hard because he'll put in $1 million for fire for personnel, and so you got to find another $1 million. If you take it out of the E911, you got to find another $1 million somewhere for fire. But those are the challenges that we all face. I don't think anybody in here, kind of intentionally does away with not trying to follow it. But that's how and what we've had. It's the same with TAF. As we see the chair many times struggle to protect the integrity of that fund, and the former chair struggled to protect the integrity of that fund. But it is a challenge, and I think that it certainly is a good step in terms of ensuring that that we adhere to that policy as much as we can, and it is a good thing to put it into policy by putting that provision as part of the law, and I certainly support it. Thank you.
You're welcome. Is there anybody else who'd like to speak? So on the amendment then, which is to create a new section 2, and rather than bifurcating this two, but it actually then there'll be a section 4. Is that what you would like to do? You want to bifurcate these two then?
Yes, Madam.
Okay, so does anyone have any comments? None? So then, no objections? So ordered. Thank you. Senator, you still have the floor.
Madam Speaker, my second amendment, I'm sure if you have a copy before you, is to add a new Section 3 to the bill as follows. The collection of 911 surcharge. Item A, each local exchange carrier, voice over internet protocol provider, VoIP, and commercial mobile radio service provider shall collect the surcharge as established by the Commission and identify such a separate line item on its invoice. Madam Speaker, there's aside from the surcharge charged to the line lines, this issue was also raised at the public hearing on voice over internet protocol and VoIP, that there may be potential in the future that because this is not in the language at this time, I believe when the law was put in place, VoIP was not a technology in place at that time. We're just taking a proactive approach to ensure in the future that VoIP, because VoIP has access to emergency 911 service as well, that it be assessed a 911 surcharge as well, to also ensure that in the future that any provider with VoIP will be assessed this, and it will be clearly outlined in the law. But I also like to note, Madam Speaker, that there is companies out there that are already paying a surcharge specific to VoIP. However, because it's not specific in the law, I would just like to include that.
Okay. On the amendment, which is for a new Section 3, Vice Speaker?
Thank you, Madam Speaker. If the proponent would yield, I have to apologize first for my not knowing technology that well. But I was just wondering how, unless you're part of the NSA, you would know that I signed up for VoIP at home.
Senator, do you yield to the question?
I didn't get, what's the question, sir?
How would the government, unless you have a hookup with the National Security Agency, know that on my computer at home I signed up for VoIP? I mean, I can understand if I go to GTA, but when I sign up for VoIP on my computer and Viper and everything else, I don't see how you guys are going to know. I don't know. I don't know technology that well, but sometimes when people put things on my phones, I don't see how the government knows that it's on there.
Well, I understand. Thank you for the questions, Speaker, Vice Speaker. I clearly understand that the tracking of this will be a challenge, but the FCC has adopted rules specific to services to the supply of 911 emergency call capabilities. So there is rules in place that have been adopted by the FCC to determine this.
On the amendment,
You're talking about like Skype and all that?
yeah, Skype, yeah. So, yeah, Skype, you're right, and FaceTime.
But
Oh, can you just, yeah, so speak to those two first. I'll give you the opportunity.
Okay, thank you, Madam Speaker. I again, for the record, the FCC has adopted rules to address this concern, and I'm sure that our telecommunication or local telecommunication carriers or are aware of this ruling, these rulings to address those providers of VoIP.
Okay, on the amendment, Senator San Nicolas? Oh, okay, so, all right, so he will let you go then, so Senator Michael Michako.
Thank you, Madam Speaker. If the author could yield to a question regarding the charges associated with the VoIP lines. Typically these VoIP features, right? They have an assigned IP address per phone, and is that considered a line? And if so, with the current or the initial bill as introduced, it's specific to remove the maximum of 25 access lines per account, and now it's charging every line this new e-surcharge, right? So how will they handle the VoIP lines? Because in my understanding, because our business uses the voice over IP, each of our phones is designated an IP address, right? And so that's how the phones are routed through the server, and then the calls are made, through the internet. I don't, and typically when you have a 911 surcharge, it's associated with a landline, and so VoIP lines you could have multiple VoIP lines and only need one landline in order to access 911. So is this amendment suggesting that every IP address is going to be charged for access to that, when really they're not utilizing the VoIP lines to make 911, they're using the one landline to make the 911 call? So I don't know if the author can answer that or not.
Madam Speaker, if I could take a 1-minute recess. Yes.
Okay, we're going to take a brief recess. Legislature's back in session. Senator Mike Limchaki, you still have the floor.
Thank you, Madam Speaker, and thank you for the opportunity to discuss with the author. We found a section of the main bill that we can address the issue of concern that I had. So I'll go ahead and he has thoroughly answered the question, and after the I'll speak on the main motion and make an amendment to address my concerns. So.
Okay, so yeah, you're right. So you're not speaking on section 3.
Correct.
Okay. So in section 3, the new amendment, Senator Nicholas.
Thank you, Madam Speaker. I kind of wanted to echo the same concerns raised by Vice Speaker Cruz concerning the voice over internet protocol section. If you have internet access at home, you can make phone calls using Skype. And Skype is a voice over internet protocol service provider. And the way the language is written in this amendment is that they shall be charged the surcharge, but there is no existing mechanism for that surcharge to be applied. And one of the things that concerns me about the amendment is that if we are saying that they should be charged and they're not being charged, do all of the other providers then have an equal protection question that they can challenge being charged as well, saying you're supposed to charge this guy but you're not, and you're still charging me, therefore we refuse to pay those charges because the law is not being equitably applied. So that's my concern with the amendment is I see the intent. There is voice over internet protocol service providers on the island who are allowing for phone calls to be made over the internet locally, and the intent in the amendment, as I understand it, is to also allow for those on-island providers to be assessed a fee. But what about for because the way the amendment is written, it applies to voice over internet protocol provider, period. What about for those who we don't have a way of actually assessing the surcharge to, such as Skype or those other platforms? So if I could, I guess, just pose a question to the author. Maybe he has an explanation, or perhaps we might want to specify local voice over internet protocol providers.
Senator, do you yield to the question?
Yes, Madam Speaker. The previous speaker has clearly same concerns as addressed by the Vice Speaker and Senator Limtiaco as well. And to answer that question very specific, Senator Limtiaco, we've agreed also would address that in the main motion as well as an amendment, but that we're looking at to addressing the language to be specific to subscriber. So that would address that issue clearly.
Okay. Senator, was he able to answer your question, or do you want to follow up with another question?
I'll go ahead and yield to the author at this time, and I guess see where things go, and perhaps we may return to amend the amendment if it doesn't get addressed later on. Thank you, Madam Speaker.
You're very welcome, Senator. On the Section 3 amendment, are there any others who would like to speak on it? There being none, Senator, do you want to close on Section 3?
Thank you, Madam Speaker. I appreciate the colleagues' concerns, and we look forward to also addressing those concerns in the main motion.
Okay, so on the amendment then, are there any objections to the new Section 3? There being none, so ordered. On the main motion, I recognize Senator Limtiaco.
Thank you, Madam Speaker. And Madam Speaker, on the main motion, one of the issues that have been brought up is how these voice over internet protocol is going to be assessed, and how will they know if we're using VoIP. And I think we can address it if we change just one word in Section 1, line 6, and changing the word access line to subscriber line. And so basically, when you sign up or you subscribe to the service, that's when it'll be assessed, and that's when we will know. So you can still have a subscriber line with in conjunction with your VoIP in order to access 911 calls. And so by changing that access line to subscriber line, one, it'll limit the charges to just a subscriber line and not necessarily to all the other IP addresses that are associated with the VoIP system. It'll just be charging the subscriber line. And typically one subscriber line or a couple of subscriber lines are used in these VoIP systems to access 911 or to actually dial out. So by changing the word access to subscriber, I believe it will address the concerns regarding the VoIP and also limit the charges associated with the VoIP systems to just the subscriber lines.
Okay,
So that is the amendment, just changing section 1, page 1, line 6, changing the word access to subscriber.
on the amendment, which is to change access to subscriber, I have Senator San Nicolas and Speaker Bev. Senator, you recognize?
Thank you, Madam Speaker. I kind of see where the intent of the amendment is going. It kind of makes, I have mixed feelings about it, because now what we're doing is the intent of the original bill was to take out the 25 access lines, and just as many access lines as you have, you're going to get assessed that $1 charge. There are businesses that, of course, do use voice over internet protocol technology where they have a very limited amount of access lines, and then they attach, as was explained earlier, all of these different IP addresses that funnel through that single line. What happens is, if we do adjust the language in this way, we may be creating an unfair environment that is more beneficial for those businesses that are providing voice over internet protocol services versus those that are using standard landlines throughout their company. And then the other concern that I had was, what is the dollar for? Is it to, this surcharge is to help E911. And the help is supposed to be in the form of being able to have the adequate manpower and resources to address demand. And so if demand is based on the number of potential calls that E911 may be getting, then that demand can come from anywhere. It can come from voice over internet protocol, which may have one subscriber line, but 100 IP addresses attached to it. Or it could come from 100 direct access lines, individual homes, 100 individual homes, for example. But the way it's going to end up now with this amendment is that the demand that is out there from voice over internet protocol will not be charged the same as the equivalent demand that is out there that is not being administered through voice over internet protocol. And if ultimately the charge is intended to offset the potential demand from the number of calls that may be coming into the system, and to support the E911 system based on that potential demand, then we need to really look at it from a demand side and not necessarily from a line side, because you may be using one line, but your demand potential could be exponential. If the entire island moves towards greater IP usage, we're going to see reduced E911 charges, but the same demand. And in the end, what's going to happen is that the E911 system would be borne more on the backs of individual consumers, homeowners, disproportionately to the same demand that might be coming in as a result of business entities that have multiple lines and multiple call channels, but a single subscriber line. And so I'm just trying to, I'm wrestling with that.
I think that should.
Because the way the law is originally written is that, you know, no matter how many ways you're able to call in, after 25 lines, you're cut off. You know, you're not going to get charged more than that. But now, you can have 250 IP phones, one line, you're going to pay $1. And so we're actually going to be reducing potentially the amount of money coming into E911 from those who utilize voice over internet protocol. And E911 will be more, the burden of maintaining the E911 system will be more disproportionately put on the backs of individual line subscribers who are mostly our homeowners. So I'm not quite sure how I feel about that amendment. But the other side of the coin that we've talked about earlier is then thereafter, if we don't create that kind of special environment to accommodate the voice over internet protocol, how do we assess the charge to that? You know, do we do it based on the IP address, and then how is that going to be applied, and who's going to be responsible for collecting that? This is one of those challenges where we have a funding mechanism set up to support a critical public service function, but that funding mechanism is having a very difficult time adapting to the technologies that are coming out and impacting the way that funding mechanism is supposed to be providing the support. So even if this amendment did not pass, we would still have the challenge of how are we going to assess the charge to the voice over internet protocol providers? How are we going to collect that fee, and how is it going to be who's going to be responsible for it? I don't know. I just know that right now, because we've entered into a new territory with this bill and with the technologies that are out there creating these questions, we need to really understand how we're going to move forward in a direction that's going to provide the support we need for E911, but in a way that is going to be fair and equitable for everybody who has the same potential to impact the demands on the system. So on the amendment, I just wanted to make that statement. I'm not quite sure how I feel about the amendment in particular, but as these amendments now apply to the whole bill, I think that the entire construct may need to be revisited so that we can get more clarity on these items. Thank you, Madam Speaker.
Welcome, Senator. Speaker Pangilinan.
Thank you very much, Madam Speaker. Madam Speaker, I rise to just kind of voice some questions, and maybe when the author in his closing on the amendment would be able to clarify it, and maybe I wasn't part of some of the offline discussion. But the intent of the bill is that every single telephone that can dial 911 should be paying $1 for support of that 911 service. And I guess another question I have is, what if I have one telephone and 5 extensions? Do I now pay $6? You know what I mean? Because it's all the same number. So is it every instrument? Is it every telephone line that is able to transfer that call out? I believe it really is probably every single line that is paid for that is able to transfer the call. The extension, without being hooked up to the subscriber number, cannot make a phone call. So in that case, I think it's just that single dollar. But again, so on the voice over internet protocol, if the amendment that is being proposed, to me, it's like, is it that scenario of one IP address, and you now have other instruments that are able to access that, but without that IP address, it wouldn't be able to go through, and therefore that should be counted as one access line and not, and should only be charged $1. I'm just not sure, but that's how I'm trying to kind of connect the two technologies and ensure that the application of that dollar to the technology of land-based line and when it should be paid, and the application of the VoIP technology and its ability to connect those calls should also be charged that subscriber line in the same fashion. And I think that's what I don't completely understand at this time, and hoping that I can get an answer once the discussion continues on this.
Thank you. Is there anybody else who would like to speak on the Limtiakos amendment? Okay, so my understanding is in page 1, line 6, that in place of access is to put the word subscriber.
Subscriber. Nice. And if I could, because the prior speaker brought up some good points, and this is my understanding as well, that this subscriber line is a line that you use to access 911, right? You cannot do it without having a subscriber line. So you're paying for that dollar fee based on the subscriber lines that you have access to. So in the case of like a VoIP system, right, it's my understanding that you could have 30 lines, 30 IP addresses, 30 IP phones, and 5 subscriber lines, let's say, right? You're paying for all those subscriber lines, but all 30 phones couldn't access those 5 subscriber lines at once. You can only access 5, the number of subscriber lines that you have, right? So if you could have 30 phones, but if everybody gets on the phone and tries to call, only 5 are going to be able to do it because it's based on the subscriber line. So you're still paying $1 for every subscriber line, and you're not increasing demand because all 30 can't do it. You're limiting it to how many subscriber lines that you actually are paying for to access 911. That's my understanding of how it works. So you're still paying what you would be on the subscriber side. But if we use the word access, you potentially could be charging for, let's say you had 30 unique phone numbers in your system, but you only have 5 subscriber lines. The other 25 are going to be charged $1 for that access line, even though it's not an actual subscriber line.
Senators, I think
No, you can.
we're going to
because
take a recess here so you can have those side conversations, and then when we're ready to come forward, then I would call you back on. Recess. Session. I know there was a lot of discussion on that amendment, on Limchaco's amendment, and I'd like to go back to the mover of that amendment.
Okay.
Senator, as part of your closing.
Thank you, Madam Speaker. Madam Speaker, after discussions with my colleagues, what we want to do is I want to withdraw the amendment to change the word access to subscriber and go back into Section 3 and just amend the section on VoIP to address.
We'll take care of one. On the motion then to withdraw the amendment of from access to subscriber, no objection?
If the gentleman would just yield as to, so where do we get the definition that differentiates between access and subscriber line and?
Okay, so
Yes.
Senator, do you yield to the question?
Absolutely. So the author of the bill had determined that the current FCC usage of determining the language, whether it's access or subscriber, the FCC uses the word subscriber. So did I answer your question when we got the differentiation? So when we were determining whether we should use subscriber or access line, the author had went to see what the Federal Communications Commission uses, and they do refer to subscriber as opposed to access. However, for the purpose of the amendment, my concern is really where it applies to the voice over internet protocol. And rather than change all the areas in which access or subscriber are used throughout the law, we want to just address it in the voice over internet protocol section, which is in Section 3. And therefore, that's why I'm withdrawing the amendment so that we can go back to Section 3 and just put it specifically where it applies to the voice over internet protocol.
Okay, so on the motion then to withdraw the amendment, no objections? So ordered. Okay, and so Senator, you want to do, notwithstanding, of course, the actions of the body now in which we have passed Section 3, that's your motion.
Yes, ma'am. So if we can get a 1-minute recess so we can determine how we want to move forward.
Okay, you sure now? Okay. Session. I would like to recognize the mover or the author of 140 for a motion.
Madam Speaker, I'd like to motion to recess and after lunch. We'll address this issue throughout lunch and come back right afterwards and have address these concerns. Thank you.
All right, so senators, then there's more work to be done. So therefore, we will recess until 2 this afternoon.